Okay, class. For Module 2, okay, our topic will be the sources and limitation of criminal law. Okay, so the criminal laws in the Philippines, we have four sources. Okay, four sources. The first one is the Revised Penal Code. Okay, that is our Bible for this course. Okay, the Revised Penal Code. So before I forget, I think I need you to have a copy of the Revised Penal Code. Okay, you can download it. Okay, you can download a copy of the Revised Penal Code in the internet, or you can install an application in your phone or your smartphones. No, there is a application for the Revised Penal Code, as well as you can also buy a Codal. Okay, the book. Okay, of the Revised Penal Code. It will be useful in our succeeding topics, because most of our topics will be based on that based on that criminal code, okay, or the Revised Penal Code. Okay, so please have a copy with you of the Revised Penal Code. Okay, so that is the first source of criminal law in the Philippines. Second are the laws passed by Congress, okay, or of the legislative branch. In the current setup of the government, we have Congress, the House of Representatives, and the Senate. In the previous form of government, we have what we call Batasang Pambansa, the Philippine Assembly, and those are what we call the legislative branch of. To be short, as to the sources of what we call this, of the criminal law, we need to the criminal laws passed by the legislative branch. Okay, then we also have criminal laws based on the presidential decrees during the martial law, because during the martial law, the president has dual powers, the executive and the legislative. Okay, so the president, Ferdinand Marcos has the power to enact laws of criminal nature, through the issuance of PD, presidential decrees, and we still have several PDs that are still used in our that are still being used, or what we call as still good laws. Okay, those laws that has not been revoked, okay, by or amended by another law. Okay, PDs, and we also have penal executive orders. Okay, for example, the orders made by the then President Rodrigo Duterte, punishing those people who smoke outside the residences. Okay, so those are some example of penal executive orders. Okay, I just want to emphasize that there is no common law in the Philippines. What we mean by common law, in England, in some parts of the United States, their laws are not similar to ours, because the body of their laws is based on their common practices. In our country, in Philippines, we don't punish someone if it is not based on a law enacted by Congress. Okay, that is clear. All laws should be penalized under the following: the Revised Penal Code, the special laws passed by the legislative department or a legislative branch, the penal presidential decrees issued during the Marcos time or during the martial law time, and the penal executive orders. Other than that, we don't punish any acts. There's no punishment for an act that are not covered under those four sources of laws. Okay, and then as I mentioned earlier, it is the state through the legislative branch who has the power to define and punish crimes under their police power. Okay, now the limitations of a criminal law. Okay, limitations imposed under the Constitution. Okay, we have under the Bill of Rights, no, that there should be no ex post facto law, okay, or bail of attender. Sorry. Under the Bill of Rights of the 1987 Constitution, the Senate or the Congress is prohibited from passing an ex post facto law or a bill of attainder, and that no person shall be held to answer for a criminal offense without due process of law. Okay, those are the two most common, or the two constitutional limitation of criminal law. So let's discuss first, what is an ex post facto law? Ex post facto laws are the laws that punishes crimes that were committed, or acts that were committed prior to the enactment of the law. Okay, for example, the Congress passed a law. This is just for discussion purposes. Okay, what is ex post facto law? The Congress passed a law that prohibit students from using a pencil. Okay, for whatever reason, the Congress may have, it punishes someone from using a ball pen. Sorry, I need to readjust my camera. Okay, so what is an ex post facto law? Those students who use a pencil prior to the enactment of this law will also be punished. Okay, those students who used the pencil even before the enactment of the law will also be punished. Okay, if that is the tenor of the law, then that is an ex post facto law, and it is prohibited by the Constitution. Meaning, you cannot punish someone from doing something that is not yet punished by the legislature. Okay, or you cannot punish someone by committing or by doing something to which at the time of the commission is not yet penalized by a law. Okay, so that is an ex post facto law. Also, it is considered as ex post facto law if it is also considered ex post facto law if you increase the penalty of a crime. For example, the crime of theft. Just for example, if the penalty at the time that you committed the crime of theft is, let's say, 6 months, and then in the new law it make it 7 years. Okay, so it's 6 months versus 7 years, and that 7 years will be applied on all the previous acts committed, or thefts that were committed. Then that is ex post facto law, as you increase the penalty. Okay, and then in other words, no, to make it short na lang, no, because you have the definition of what is an ex post facto law. Anything that makes the crime, or the penalty more severe, will make any laws that is passed that will make the crime or the punishment thereof severe is considered ex post facto law if it is applied on the previous acts done prior to the enactment of the law. Okay? Yeah, the ball pen, the pencil example is a very concrete one. Okay, so if you use a pencil today, no, and it is not yet punished because the law passed prohibiting the use of pencil will be passed in, like, say, a year after today, then that law that prohibits the use of pencil cannot penalize you for using the pencil today. Okay? Okay. So that is ex post facto law. The Bill of Attainder is a law that provides a penalty without judicial trial. Okay? So meaning, if the Congress will pass a law that automatically sentence a person for committing something, no, without due regards of due process, then that is a bill of attainder, and that is prohibited by law. Okay, so we need to go through the criminal procedure. Okay, we need to go through the process under the criminal procedure, without which, if the law will provide that a penalty will be automatically inflicted or implemented against a person without due regards to due process or the criminal procedures, then that is bill of attainder. Okay? Okay. So, again, those are prohibited, ex post facto and bill of attainder. Now, you need also to familiarize yourself of Article 13, Article 3 of the 1987 Constitution. It provides safeguard against people or against us, no, from the enforcement of the laws, of criminal laws. Okay, so you need to read, okay, the provisions under the Bill of Rights. It's not, I don't think it is very relevant or very important for us to discuss each and every articles of Bill of Rights. You can discuss that in your constitutional law class. Okay, so please read the articles or the sections under Article 3 of 1987 Constitution that provides safeguard against the illegal enforcement or unlawful enforcement of criminal laws. Okay? Now, there are three characteristics of a criminal law. First is that it has a general application. Okay, there are three main characteristics of criminal law. Okay, I need to repeat this. This is important. First, general in application, territorial in application, and prospective in application. Meaning, all laws or all people sojourning or living in the Philippines are covered under the under our criminal laws. For example, if a person killed someone in the Philippines, whether that person who killed that person is a foreigner, then our laws will be applicable to that person because the criminal laws are applicable to all people sojourning or residing in the Philippines. Exception are those under our treaties, no? There are treaties that exempt people, certain individuals, from being covered or from being covered under our criminal law. So example to this are the sovereigns and chief of states. For example, President of the United States, the Pope, okay, if they commit criminal acts in the Philippines, they cannot be prosecuted under our laws. Okay, that is under treaties, including other people other than the sovereigns, which are exempt from the general application of the criminal laws, are the following: the ambassadors, ministers, plenipotentiary, minister residents, and charge the affairs. Okay, so charges the affairs. I'm not sure if I pronounce it correctly. Okay, those are the certain individuals who are exempt from the general application of criminal law. Territorial jurisdiction, okay? Territorial application of our criminal laws. Meaning, all laws, the criminal laws are only effective. Our criminal laws are only effective within the territorial bounds of the Philippines. Meaning, our rape law is not applicable in the territory of Singapore, China, or any other country, but it is only applicable within the Philippines. Obviously, in every law, there is an exception. So, the following are the exception to the territorial application of laws, of criminal laws. First are the crimes committed in the while in the Philippine ship or airship. Okay, if you committed for example, murder in a ship registered under the Philippine laws. Okay, if you commit a crime within that ship, Philippine ship, and you committed that in the high seas or in the territory of, let's say, United States, then the law of the Philippines will be still applicable, because those airplanes, and that ship, excuse me, are considered extension to the Philippine territory. Okay? Next, should forgeries and counterfeiting of Philippine coins and currencies, okay, and other securities issued by the Philippine government. For example, you forge or you counterfeit the coins, paper money, paper bills of the Philippines in Singapore. Okay, you committed the counterfeiting or you make fake Philippine money in Singapore, you can still be held liable under our criminal laws. Okay? Extraterritorial application of criminal law. Okay? These are the example of extraterritorial application of our Philippine criminal law. Next, while being public officers and employees, and the offense you committed outside the Philippines is in exercise of your official functions. For example, you committed crimes of bribery. Okay, you committed you bribed someone in, let's say, in Japan, no, and the bribery is in relation to your official function as an official of the Philippines, no, as an officer, as an employee of the Philippines. You went to Japan and bribed someone for a government project, even if the crime was committed in the territory of Japan. Okay, but you are a Filipino officer or a government employee or government officer in the Philippines, and the action is in relation to your job or function, official function, then you can still be prosecuted under the criminal law. Okay? Laws, these are crimes punished under Title 1 of Book 2 of Criminal Law. Okay? Crimes against national security. Okay? Espionage, some of my example. Other examples under Title 1, Book 2 is espionage, I cannot, not terrorism. Basta, I cannot remember. I have a very bad memory, you know. Even if I'm a lawyer, I have a very bad memory. So examples of crimes, all crimes under Title 1, Book 2 of the Revised Penal Code, or the crimes against national security and law of nations are can be still punished under the Revised Penal Code. Like for example, piracy. Okay, piracy in high seas, you can still be prosecuted using the criminal law of the Philippines. Okay, prospective application. What do you mean prospective application? This is in relation to our discussion on ex post facto laws, no? That the law should only be applied prospectively, meaning you cannot punish someone for their past offense. The penalty or the punishment is prospective, future in application, futuristic in approach. Okay, meaning if the penalty is passed today, then all acts that are punished by that law, by that certain law that is passed or that is effective today, and the succeeding acts can be punished. Okay, but not the acts that are committed prior to the passing of that law. Okay, exception are the following: if the penalty is less severe or less serious or less grave or lighter, the penalty is lighter, then it can have a retrospective application. Okay, it can be retroactively applied. Okay, if it is more favorable to the persons held in custody or persons punished under a criminal law. If it is more favorable to that person, then it can be applied retroactively. Okay? If it is more lenient or favorable. Exception to the exception is that if the law expressly provides that it cannot be applied retroactively. For example, if Congress will pass pass an amendment to the law punishing rape by reducing its sentence, okay? For example, the current penalty for rape, let's say 15 years, okay? And then the Congress pass a law amending the penalty of rape, lowering it from 15 years to 10 years. Okay, so under the prospective application, the 10 years that the 10-year penalty can be lowered, that was lowered by that law, should be applied prospectively. Okay, but since it is lenient and it is favorable to the person convicted of the crime rape, then it can be applied retroactively. So, pwede siyang i-apply dong sa mga tao na penalized na or na penalized na or are currently serving their sentences for rape. Okay? However, an exception to the exception. The exception is the retroactive application of a more favorable law. The exception to that, if the law itself provides that there is no retroactive application, then the law, whether it is more lenient or favorable to the accused or to the person serving the sentence, cannot be applied because the law itself provides that it cannot be applied retroactively. Okay? And if that person is a habitual offender, we will also discuss what is an habitual, quasi-recidivist, and recidivist. But the law is very specific, habitual, criminal, and we will have a separate discussion to that. Okay? Before we end our module 2, we need also to understand mala inse and mala prohibita. Mala inse is the act is wrong by its very nature, and the criminal intent is an element of mala inse. Okay, meaning there must be a criminal intent. Okay, intention is important. Okay, for example, in rape case, the intent to have carnal knowledge or to have sex with the person is important. Meaning, if if for whatever reason you have a sexual intercourse with a woman, without having an actual intent to do that, then that is not a crime of rape. Okay, because the intention is important. Okay, is there any reason, sir, for you to commit rape without intending to commit rape? Yes, for example, in somnambulism, okay, a case of somnambulism, it's a medical condition whereby a person, like the sleepwalking, he or she is asleep, and when he or she is asleep, he do some unconscious acts such as raping or killing a person. If it can be proven in court that the rape or the killing was committed at the time that he was asleep, then there is no intention to do such heinous crime, then he or she cannot be liable for that rape or whatever it is. Okay, that is mala inse. Intent is important. These are crimes referred under the punished under the revised penal code. Okay, most of the crimes under the revised penal code are considered mala inse. In short, you need to prove intent. Like for example, in robbery and theft, intent to gain should be proven. Okay, intent to gain should be proven. In murder, intent to kill should be proven. In homicide, intent to kill should be proven. Intent to kill can be proven by the fact of death. Okay, intent to gain from the fact of getting or acquiring something that you don't own. So those are the things that you need to understand in criminal law too. Okay, because those are elements. We're talking on specific elements of a specific crime. But for this lecture video, you just need to associate mala in se with intent. Okay, mala in se, intent is an element of the crime, and these are the crimes under the revised penal code. Mala prohibita, okay, mala prohibita are those crimes that are intent is not material. Intent is immaterial. Whether you have an intention to do something, whether you have an intention to do something bad or good is immaterial because it is prohibited by the law. It is a regulatory infraction. Regulatory infraction in nature, meaning if Congress pass a law prohibiting the use of a pencil, okay, and you still use a pencil in writing, whether you have a bad or good intention, that is immaterial. The fact that there is a law prohibiting you from using a pencil makes your action of using a pencil in writing criminal act. Okay, so clear, the intention, whether you have a good or bad intention, is immaterial. Mala prohibita, more on the special penal laws, the Republic Act, for example, the bouncing check law. Okay, so whether you have a bad or good intention in issuing a bad check, okay, that is immaterial because the law itself provide that you cannot use a worthless check. Okay, then mens rea, guilty mind, and actus reus, guilty act. These are just definitions and some Latin phrases. Okay, so that would be all for module 2. I will upload maybe tomorrow module 3 to 5. Okay, so thank you.